I'm going to tell you a story about a client that recently came through my office who is probably like many of you. He started generational wealth and he unfortunately had it set up all wrong. My name is JP Rankin. I'm an estate planning attorney licensed in South Carolina, North Carolina, and California. I've helped hundreds of families avoid probate, create an estate plan, and a legacy that they're proud of and they know is going to work. In this video, I'm going to tell you exactly what we did. All right, story starts. Frank is not his real name, but for this, he's going to be Frank and Mary. Okay, his wife Mary. All right, they fell in love. They wanted to start a family. And what did they do? They wanted to figure out a way to create that generational wealth, right? So they bought a multifamily home as an investment property. But because they didn't want to talk to an attorney and they thought they could do it all themselves, which is totally a normal thing, they bought it in their personal name for $1 million, okay? Luckily, it didn't need much renovation, so they got some tenants in there quick, and they were able to make some money off of this investment, some passive income. So what did they do with that? They bought themselves a nice big mansion. And by mansion these days, I just mean a house big enough for them and their 3 kids, okay? So 3 kids, they all 3 live in this mansion with a very big garage where Frank and his kids love to go hang out, which is the American dream, right? Everything was in their personal name. This house, by the way, $1 million home at home as well, okay? So right now, aside from all of their other accounts, they've got $2 million of assets that they own. And they have no plan whatsoever. No plan for their business assets, no plan for their personal assets. So what happens without a plan is the laws of intestacy are going to govern who gets what and in what amount when you die. And the laws of intestacy are interpreted by probate court. So when you go through probate court, they take a fee, and it's a very long process, in my opinion, that you can avoid. So in South Carolina probate court, there's a minimum creditor claim period of 8 months, and then it takes anywhere from 4 to 6 months after that to close out your whole entire estate and then distribute it to your 3 kids, right? So probate court fees, they're based on your total probatable assets, which is his investment property and his personal property, which are totaled at $2 million. So 3% of that, what's that give you? $60,000 going to probate court simply so that your loved ones can receive all of your hard-earned work and assets. Not to mention, this process takes some time. The value of his home could go up or down. The value of his investment property could go up or down in that time period. So what did we do to help Frank and Mary? First things first, this investment property, we need to get it out of their name and put it into an LLC. So that's what we did. ABC Investments LLC. Now, it's in a business entity. When it's properly formed and follows all of the business entity formation rules and regulations, the court is going to say that this is no longer their personal asset. It's an investment asset of LLC or ABC Investments LLC. So when one of the tenants that lives in this multifamily unit falls down and they say it's because Frank didn't fix the stairs soon enough, that's not Frank's problem. That's the investment company's problem. So now they can only sue the investment company, and that investment company only owns this one piece of property. So whatever the judgment is, if it was Frank's fault, can only be assessed against their investment properties. It cannot be assessed against their personal residence. Before we formed this, if the same scenario happened and it was Frank's fault, not only could they access his investment property that was in his name, but they could also come after his personal residence that was in his name. So we saved him a lot of money there by creating this business entity. Then what we did is we put a revocable living trust in place, okay? This is a contract between the grantors, Frank and Mary, the trustees, and the beneficiaries, their 3 children, okay? So once this thing is properly funded, it goes from being an expensive stack of papers to a contract that is going to save your family from probate and distribute all of your assets virtually overnight. What's going to happen is the successor trustee is going to instantly own everything that the trust owns when both grantors pass away. So what we did is we took his personal residence and we put it right into the revocable living trust. We changed the title to that residence to be owned by the revocable living trust. And then we took his LLC interest and we assigned that interest to the revocable living trust. So now he's got his personal residence funded to the trust, his interest in the business assessed to the trust, so that now when Frank and Mary end up passing away, there is no probate court to go through because they don't own anything in their own name. So there is no fee that can be assessed to any of their assets because they don't have anything in their estate. Everything is owned by the revocable living trust. So that is how we saved Frank and Mary and their 3 kids, moreover than Frank and Mary, because the kids are the ones that are going to be paying this out of the estate, $60,000. So if that sounds like something that you might need some help with, or at least some advice from a licensed attorney, go down in the link below and hit us up and we'll be more than happy to talk to you about how to potentially save you and your estate a whole bunch of money.